Bismillahirrahmanirrahim. Assalamualaikum and good day. My name is Zainab Zahra Binti Muhammad Amin, and I am presenting this case study for Professor Madya Dr. Haji Muhammad Shanawi bin Haji Muhammad Firoz for INC 500 Industrial Relations, Regulations and Cybersecurity. The case I chose is To Siwei versus Tedrick John Moore and another, reported at 2017 Volume 11 MLJ page 67, decided by the High Court in Penang. This case deals with an alleged email hacking incident at a workplace, and it raises important questions about invasion of privacy and breach of confidence under Malaysian law. Over the next 15 minutes or so, I'll walk you through the facts, the legal issues, the judgment, and my own analysis and critique of the decision. Before I go into the facts, let me briefly explain why I picked this case for a cybersecurity assignment. At its core, this case is about whether someone's private email account was hacked into without their consent and whether the information taken from that account could lawfully be used against them. It directly engaged Section 8 of the Computer Crimes Act 1997, which deals with unauthorized access to computer material. It also tests whether Malaysian law recognizes a proper standalone thought of invasion of privacy, something that it is still quite unsettled in our legal system. And finally, it shows how the equitable doctrine of breach of confidence applies when private communication are leaked. So this case sits right at the intersection of cybersecurity, employment, and civil law. Let me introduce the parties involved. The plaintiff is To Siwei, who was the Chief Operating Officer at Penang Adventist Hospital, or PAH for short. He claimed that his private Hotmail account was hacked and that the emails obtained from it were later used as the basis for his summary dismissal. The first defendant is Tedrick John Moore, who was a trustee and also the Chief Executive Officer and President of PAH. He was the one who produced printouts of the plaintiff's emails at a Board of Trustees meeting, although he denied hacking the account himself. The second defendant was the Vice President of Medical Affairs at PAH, essentially the Chief Medical Officer. He admitted to obtaining copies of the emails from the first defendant and showing them to at least 5 other people. Now, let's go through the timeline of the events. On the 7th of July 2011, while the plaintiff was overseas, he suspected that his personal Hotmail account had been hacked and that emails were being diverted to other accounts. He lodged a complaint with the Windows Live team and reset his password. Around mid-January 2011, according to the first defendant, he received an unmarked envelope from an unknown person containing printouts of the plaintiff's email in two outsiders. Then on the 11th of July 2011, when the plaintiff returned to Penang, he was handed a letter of summary dismissal citing disclosure of confidential hospital information and conspiracy against the first defendant. 10 days later, on the 21st of July, at a Board of Trustees meeting, the first defendant showed printouts of about 1,000 of the plaintiff's email. The second defendant admitted he was already aware of their contents. At the meeting, the plaintiff was allowed to resign instead of being formally terminated. Moving on to what happened afterward. On the 29th of August 2011, the board actually dismissed the first defendant as CEO and suspended the second defendant. Interestingly, the two defendants that sued some members of the board in separate proceedings, and in those proceedings, they exhibited more than 20 of the plaintiff's emails as evidence. The plaintiff himself was not even a party to those suits. In May 2012, the plaintiff lodged police reports. first in the United States and then in Penang, after waiting for the outcome of his complaint to the Windows Live team. He then filed this suit in 2012, about a year after his termination, claiming invasion of privacy and breach of confidence. He sought 2 million ringgit in general damages, a permanent injunction to stop the defendants from using his emails, and an order for the emails to be delivered up to him. His legal argument relied on Section 8 of the Computer Crimes Act and Section 114, Paragraph A of the Evidence Act, which allow a presumption of unauthorized access based on possession of the material. So, what exactly did the court have to decide? I've broken it down into four central issues. First, was there actually unauthorized access, meaning the first defendant or his agent hacked into the plaintiff's email account? Second, does Malaysian law recognize a standalone thought of invasion of privacy for something like this? Third, did the defendant owe the plaintiff a duty of confidence over the contents of those emails, and was that duty breached? And fourth, could the disclosure of the emails be justified on public interest grounds, and did the plaintiff's own conduct disqualify him from getting equitable relief under what's called the clean hands or equity rule? These four issues form the backbone of my analysis. Let's start with the hacking issue. The plaintiff's argument was built around Section 8 of the Computer Crimes Act 1997, which says that a person found in unauthorized possession of computer data is deemed to have obtained unauthorized access, unless he can prove otherwise. His lawyers argued that the first defendant's possession of the emails so soon after the hacking incident should trigger this presumption, especially when combined with Section 114, Paragraph A of the Evidence Act, which deals with recent possession of stolen property. They also pointed out that the first defendant had admitted his staff printed out the emails on the 19th of July, just 2 days before the board meeting, which seemed to contradict his story about receiving an anonymous envelope. However, the court's finding went the other way. There was no documentary or oral evidence showing that the first defendant or his agent actually hacked the account, and the plaintiff himself admitted this gap in his evidence. It also came out that the plaintiff had shared his email password with his own secretary, which weakened any inference that the defendants were responsible for the hacking. So, the court held that there simply wasn't enough evidence to prove hacking, and that meant the Section 8 presumption and the privacy claim built on top of it could not succeed. Now, let's talk about privacy and confidence, which are two separate but overlapping legal concepts. On invasion of privacy, the position in Malaysia is honestly quite messy. It is not settled taught under our common law, and cases like Malone versus Metropolitan Police Commissioner and Kay versus Robertson from England traditionally rejected it. Locally, we have conflicting Court of Appeal authority, with Maslinda Binti Ishaq seeming to support a privacy tort, while Dr. Bernardine Malini Malin rejected it. Article 5, Clause 1 of our federal constitution has been read in the Civil Rasa Rahsia case to include personal liberty encompassing privacy, but that's a constitutional right, and constitutional rights don't automatically bind private individuals, as confirmed in the Beatrice Fernandez case. On breach of confidence, the classic task comes from Coco versus AN Club Engineers, which requires the information to have the necessary quality of confidence, to be shared in circumstances that impose an obligation, and then to be misused. So in this case, the court found that the emails were work-related and concerned hospital affairs, not the plaintiff personally. So no duty of confidence ever really attached to them. And crucially, the plaintiff himself had circulated these emails to his friends and to outsiders, which means he couldn't credibly claim that they were private or confidential anymore. So, what did the court ultimately decide? The claim was dismissed, with costs awarded against the plaintiff. On the balance of probabilities, the plaintiff failed to prove his case against both defendants. Let me highlight five key holdings from the judgment. First, no duty of confidentiality was owed because the emails were work related and there was no evidence linking the defendants to the alleged hacking. Second, the plaintiff's own conduct was improper and equity could not protect someone who had circulated harmful material about his own employer. This is the unclean hands principle. Third, the disclosure of the emails to the board in a court proceedings was justified by compelling public interest that outweigh any confidentiality interest. Fourth, the email didn't substantially concern the plaintiff personally. There was no publication about him specifically and no evidence that he was harmed by it. And fifth, the plaintiff had forfeited any expectation of privacy the moment he voluntarily shared that information with third parties himself. Let's move on to the analysis and critique. So for this judgment, starting with that, what I think the court got right. First, the court took a properly evidence-driven approach. It refuses to simplify, sorry, it refused to simply infer hacking from possession alone, especially once the plaintiff admitted he had shared his own password, and it declined to stretch a reverse honest provision beyond what the facts could support. Second, I think importing the inequity or clean hands defense from breach and confidence into the privacy analysis was doctrinally sound. It stops a wrongdoer from using privacy law as a shield for his own misconduct, which makes sense from a fairness perspective. Third, the court did a sensible job balancing competing interests, weighing the public interest in disclosure, which here meant protecting the hospital's governance against the plaintiff's confidentiality interest. This is consistent with older English authorities like Initial Service versus Peter Hill and Hubbard versus Fosburgh. And fourth, the judgment is genuinely comprehensive. Justice Abdul Wahab surveyed English, Indian, and Malaysian authorities, including Campbell versus MGN, OBG versus Allen, and Rajagopal versus State of Tamil Nadu, before applying the relevant local precedent, which gives the decision real persuasive depth. Of course, no judgment is perfect, and there are some real gaps here too. My biggest criticism is that the court never actually settled the core question of whether Malaysia recognizes invasion of privacy as an independent tort. Because the case was decided on the facts, meaning there was no proof of hacking, the court sidestepped this issue entirely, and the conflict between Maslinda and Dr. Bernardine Malini Martin remain unresolved to this day. Second, I noticed the judgment engaged quite thinly with digital forensics. It relies almost entirely on witness credibility and documentary admissions rather than any technical evidence like IP address logs or access records, which really reflects how limited Malaysia's cyber evidentiary practice still was at that time. Third, because hacking was never proven, the court never had to serious test how far the Section 8 presumption in the Computer Crimes Act should extend in civil as opposed to criminal proceedings. And finally, this case really highlights a legislative vacuum. Malaysia still doesn't have a dedicated civil remedy for informational privacy breaches outside of the Personal Data Protection Act 2010, and that act only really regulates commercial data processing, not situations like this one. Let's zoom out a bit and think about what this case means for Malaysian cybersecurity governance more broadly. First, workplace email has really become a live battleground. Employees are increasingly relying on intercepted or leaked emails to justify disciplinary action, and this case shows that court will scrutinize exactly how the evidence was obtained. Second, there's growing academic pressure for reform. Scholars like Trakik Karim and Tajuddin in 2023 and Ren Saw and Balan in 2022 have argued strongly that Malaysia needs a dedicated privacy act to finally resolve a conflicting court of appeal authority we currently have. Third, the hacking allegations become more common in employment disputes. Our courts are going to need much clearer forensic and chain of custody standards under the Computer Crimes Act 1997. And fourth, the public interest defense really acts as a kind of safety valve in cyber law. It gives organization a lawful route to act on leaked data that reveal wrongdoing, but there's a real risk that this defense could be invoked too broadly without proper judicial guardrails to keep it in check. To sum it up, I'd say this case is dismissed not because privacy law in Malaysia is settled, but because the plaintiff simply couldn't prove hacking and because his own conduct means he had already forfeited whatever confidentiality he might otherwise have been entitled to. It leaves the thought of invasion of privacy sitting in a real legal grey zone, recognized in principle through Article 5, Clause 1, and a handful of scattered High Court decisions, but still without a clear binding ruling from the Federal Court or a dedicated state statute to govern it. Based on my analysis, I recommend three things going forward. One, Malaysia should enact a standalone privacy act that covers both physical and informational or digital intrusions. Two, we need clearer digital forensic evidentiary standards for hacking allegations under the Computer Crimes Act. And three, the federal court really should take the opportunity to directly resolve the conflict between Maslinda and Dr. Bernardine Malini Martin. Finally, here are my references cited in APA 7 edition, including the Computer Crimes Act 1997, the Federal Constitution, the case itself, and three recent journal articles on the right to privacy in Malaysia, which you can see listed on this slide. Thank you very much for listening, and that concludes my presentation for INC 500 for cases of law cybersecurity. Thank you. Assalamualaikum warahmatullahi wabarakatuh.